I am going to talk about the deteriorating situation of Palestinian prisoners in a prison in which I just was imprisoned. And after that, I'm going to talk about the Palestinian rights in the judicial system, in the court system. First of all, I was part of the Global Sumud Flotilla, and I was in Ketziot prison, which is a high security prison, and there are many Palestinians are there. We were beaten as well and deprived of food, but nothing compared to what the Palestinians have suffered in Ketziot prison and in other prisons. Now, the issue of visibility concerning Palestinian detainees is imperative. They, however, Palestinian prisoners are subject to a process of invisibility that contributes to the dehumanization of Palestinians. So we need, together, as a global community, make the Palestinian treatment in prisons visible to the world. Now, the deteriorating conditions have been, there are many testimonies, in particular, with the prisoners that have been just released subject to the ceasefire, and the bodies that have been just released according to the ceasefire. The report by B'Tselem, it was called Welcome to Hell, that we know about in August 2024, contained testimonies of many Palestinians and women, including 21 people from Gaza, Palestinians from Gaza, who were detained in Israeli prisons. They were recently released, but had no trial. The report details torture, cruel, arbitrary punishments, sexual assaults, insults, abuse, deliberate starvation. They were burned, filthy hygiene, sleep deprivation, and confiscating of common or personal belongings and denial of needed medical care. Now, I can witness the people of Samud, we were dumped across the Jordanian border, and they took all our belongings, just like they do with the Palestinians, took all their things, all their personal things. All we had were prison clothes. Now, with respect to the bodies of Palestinians released during the ceasefire, doctors at Nasser Hospital of the southern Gaza city of Khan Yunis, which recently received Palestinian bodies from the International Committee of the Red Cross. They said that there's substantial evidence of the beatings and summary execution on the bodies, which were unidentifiable. He said almost all, and I quote, almost all of them had been blindfolded, had been bound up, and they had gunshots between the eyes. Almost all of them had been executed, said Dr. Ahmed Farah. There were also scars and discolored patches of skin on the bodies of these dead Palestinians that were just released. They showed, before they were killed, they showed signs that their bodies had also been abused after they were killed. Now let's talk about the court system, the access of Palestinian prisoners to the courts. International humanitarian law recognizes two categories of individuals during armed conflict. One, civilians, and they're protected under 4th Geneva Convention. Two, combatants. They are protected under the 3rd Geneva Convention. When captured, both groups are guaranteed humane treatment, including notification of detention to their families and eventual release. Let's talk, however, about the Israeli law. Since October 7, 2023, Israel had made several amendments to the law of unlawful combatants. And that law was first enacted in 2002. These changes aim to justify the detention of thousands of Palestinians from the Gaza Strip as part of emergency regulations to their families and eventual release. Now, since October 2023, Israel adopted laws more about unlawful combatants. The term unlawful combatant, what does that mean? It refers to individuals belonging to armed groups who are not recognized as lawful combatants by their adversary. Consequently, Israel argues they are not covered by the Geneva Convention. Israel has used this classification to justify the indefinite detention of thousands of Gazans. deeming them a security threat. Unlawful combatants law it allows for administrative detention without charge where an officer has reasonable grounds to believe the person is an unlawful combatant. Administrative detention can be therefore extended almost indefinitely. However, the law contains a problematic presumption that a member of a force perpetuating hostile acts against Israel and his release would harm state security as long as the hostile acts against the state have not yet ceased. That presumption violates the international humanitarian law, since that state must establish that the person is an individual security threat. Given the rapid increase in the number of detainees we see day in and day out, Israel probably has not even established an individual as a security threat. Now, delaying hearing, part of this law, delaying hearing before a judge 45 days, what does that mean? That qualifies an unlawful combatant doesn't get to see a judge for 45 days. In that period, there's clear likelihood that the Palestinian prisoner will not be informed of the charges against him. International humanitarian law requires a person to be promptly informed of reasons of detention. And it must be specific why that person is detained. To conclude about this section, where detention under law is not properly authorized under international humanitarian law, it can violate section, the Geneva Fourth Article, Fourth Convention, Geneva Convention, the Fourth Convention, Article 147, constituting a war crime. Arbitrary detention under Article 9 of the International Covenant on Civil and Political Rights, a violation, and enforced disappearance, and the crime against humanity of imprisonment. Finally, with respect to a lawyer, they are not allowed to see a lawyer for many days, as much as 75 days. The possibility to delay access to legal representation for 75 days in order for an official, to establish the charges, it's not complying with international humanitarian law. International humanitarian law preserves the right to have regular access to a lawyer. It's essential, important to the right of liberty. Now, what about, finally, international law and accountability? As an occupying power in occupied Palestinian territory, numerous obligations are required under international humanitarian law. Israel, with respect to Gaza, Israel controls the sea, controls the entrances, exits, the skies, and especially after the invasion, Gaza is occupied, and therefore, even without occupation, it is in complete occupation. Even without the invasion of Israeli soldiers in Gaza, we still have the complete occupation of Gaza. Under Article 76 of the Fourth Geneva Convention, relative to the protection of civilian persons in time of war, clearly outlines the right of a protected person when facing detention by an occupying power. The right is the prisoner has the right to remain in occupied territory during all stages of detention. Palestinian prisoners are currently held inside Israel, with the result that their families from the West Bank, families from Gaza, have extremely difficult to visit them. Also, under Article 78 of the Fourth Geneva Convention, occupied powers' obligation to provide adequate medical care and to provide special protection for women and children. Palestinian prisons, as we have stated before and other speakers have stated, are subject to serious medical neglect, as manifested by the case of a 49-year-old man, Mohammed Talal Abdullah, a native of the Jenin refugee camp, who died in the Asaf Harofeh Hospital in Israel on October 19th. He had died of cancer. The deterioration of his health was caused by medical neglect, as announced by the Palestinian Commission of Prisoners' Affairs. The Fourth Geneva Convention contains several provisions providing for due process and administrative justice guarantees that have been clearly violated in light of the above. In conclusion, unlawful combatants law, particularly in its amended form, has become a tool for mass administrative detention, abuse, and denial of justice. Detainees are held indefinitely under conditions that violate international conventions, including the Geneva Convention and the Convention Against Torture. The underlying strategic objective of Israel is clear. The government wants to detain people incommunicado. They want to disappear people without offering them any avenue to challenge their detention. This claimed right to disappear people was tied to an assumption of infallible security, namely that anyone who was detained was a terrorist. And this is completely infallible and erroneous. Now, the solution. Now, what we have, finally, I'm getting to the final conclusion. The solution for unlawful combatant status is to render it void. Unlawful combatant status should be void for the above reasons, is to grant combatant status, not unlawful combatant status, to most people who invaded Israel. Most of them were Palestinian citizens, whether it be in the West Bank or Gaza, who opposed or even attacked Israel. Thus, as combatants, they deserve all the protection afforded to civilians with all the protection of international humanitarian law and the Geneva Convention. Now, what can we do, the community? And this is the final statement. Therefore, the above mistreatment that I've talked about of the prisoners and the lack of access to the courts, etc., should be governed by international humanitarian law and the Geneva Convention. The Fourth Geneva Convention gives rise to the legal obligation of all 194 countries and parties to that convention to adjudicate against Israeli perpetrators of these crimes before the International Criminal Court and before the International Court of Justice.